So you are looking for a guide, a lawyer who's going to provide you with tailored legal advice, i.e. not just, a phone call or talking to a lawyer friend down the pub, but someone who's actually looked at the specific details of your case, because you need tailored legal advice. You wouldn't go to a doctor with a break, a fracture or something, and expect them not to refer you to an X-ray department. You're going to need someone to, actually do a proper diagnosis, and that means, a real assessment of your condition and asking you questions as well as actually, physically examining you. The situation is no different in respect of lawyers, and that's why the very first thing that you can do, the first sort of most affordable service that you should expect a lawyer to provide, is a legal surgery. 1 hour legal surgery costs you £150, £250 max, plus VAT. You're going to go in with your papers, you're going to have a conversation, he's going to, skim read some of the through some of the key documents, he's going to throw some light on your dispute and give you some advice, broadly speaking, which pathway to follow, which track to go down. The second type of legal advice that I would expect lawyers to provide is a tailored review, and that is basically where you send your documentation to them in advance, and I'll come on in the next vlog to explain how to do that. And you expect them to spend a good couple of hours looking through your paperwork, perhaps asking you some questions over email, and then having a phone call or a Skype call, and giving you some proper tailored advice on your claim, perhaps with a follow-up email to make it concrete. Okay, that really, as far as I'm concerned, is the very best sort of advice that you could get as a litigant in person, with a claim value of anywhere between £5,000 and £25,000 typically. That's the sort of dispute that this vlog is aimed at. Then, I think you should expect to pay between 2, 3 and 4 hours of a lawyer's hourly rate, and he should be able to provide you with a fixed fee for that service, just simply by looking through the documentation, eyeballing the dispute in a nutshell. He should be able to quote you for a tailored preliminary review of your case, tactics, the right cause of action, the true amount and value of your claim, whether it's 70% likely to win or not, and so on and so forth. Any legal issues, any limitations issues, etc., etc., etc. Now, the third type of legal advice hardly goes without mention, really, because it's just simply the old traditional taximeter rate of paying for a lawyer. The problem with that, of course, is, and it's one that lawyers have an appetite for, you get in the back of the taxi, you don't actually know how long the journey is going to be, or you hardly know what the destination is. That's the problem with litigation. It's a piece of string question. If it goes all the way to trial, rarely does a piece of litigation go all the way to trial, but if it does go all the way to trial, you could be looking at even tens of thousands of pounds, even in a reasonably low level dispute, and that's in the legal bill alone. That may be the appropriate route. We don't dismiss it out of hand. In a large complex case, then you do want to instruct a case under a formal retainer, and you want to give the lawyer ownership of the case, and for him to represent you and to conduct the proceedings on your behalf as your agent. Okay. Now, the reason I mention it here is because obviously you're a litigant person looking to run your own case. It's often, not always, but it's often the case, and I speak from experience. I can think of one of the cases we've got at the moment, where a client has done as much as they can, but the case has become quite complex, perhaps as a counterclaim, perhaps it's in a difficult sector like financial mis-selling, and they feel that the time has come, this could happen well after issue, when they would really rather instruct professionals in order to sort of carry the baton over the wire and get a settlement or win at trial. So it is well worth bearing in mind the traditional route, if you like, because tactically sometimes it can be a good idea to intimidate your opponent and in order to get them to take you super seriously particularly if they're a litigant in person, to instruct a lawyer. And don't forget, if it's of a high enough value, let's say on a higher track, a fast track claim, if you win, your opponent will have to pay your legal bill. So it can have a powerful effect on an opponent. They're faced with well-heeled professionals, and they may have to pay a large legal bill as well as the damages themselves. Final point on that is, check out your lawyer and ask them, are they prepared to enter into a contingency fee arrangement? Now, that is not a traditional taximeter arrangement. That's basically where the lawyer is prepared to work for free in return for a share of your winnings if you win. So if you lose, you don't have to pay a penny of your own legal fees. There's also, more recently, what's called a damages-based agreement, which is a bit more like an American model, like a pure cut of what you win and nothing else. And that can work often in small claims of under £10,000. So even in a small claim, it might be tactically astute to instruct a lawyer. So there it is. Those are the three ways of instructing lawyers and obtaining valuable legal advice and assistance. And legal surgery, sort of a tailored review on a fixed cost basis, and then the traditional retainer, either a taximeter or just check out your lawyer and see if he's prepared to do a contingency fee deal that's either no win, no fee or damages based agreement. In the next video, I'm going to come on to explain to you how to organize your paperwork, which is absolutely critical, because civil litigation is nothing if not a paperwork game.